is the professional really committed to an out-of-court settlement if in the back of their mind they're really positioning or strategizing about going to court?
All right, welcome back to another episode of Cover Your Assets with Joe
and Jane.
And we are joined today by Nicole Stednitz, family law attorney in
Welcome.
Torrance, California. Thanks for joining us today.
It's great to be here.
Yeah. We are going to be talking about collaborative divorce. What is that? Right. So I think, I don't know. It's probably not a relatively new option. Yeah, I don't know. Maybe. But we want to talk about what's collaborative divorce, who is it appropriate for, really what are the intricacies of it, what's the difference between mediation and litigation, all that stuff. We'll get into it. But before we get started, I'm going to tell you a little bit about Nicole. After going through her own divorce in her early 20s, Nicole went to law school at the University of Oregon School of Law and became an attorney. She immediately established her family law office in Torrance, California, to counsel other families in their family law matters. After over 10 years of grueling court battles as an attorney, Nicole made a conscientious decision to step away from the courtroom and help families transition and heal using mediation and collaborative divorce principles of conflict resolution. She counsels clients about the benefits of mediation and collaborative methods, the applicable legal issues in their case, and approaches to making informed decisions about their children, property, and support. In situations in which the family intentionally stays out of court, the end result of the case is typically less stressful, more cost-effective, more quickly resolved, and the family's privacy can be maintained as they embark on their next chapter of their lives. All right, Nicole. So I feel like for myself, even as a divorce professional, I feel like I only recently heard about the term collaborative divorce, and it's been really intriguing to me, but I think there's so much more to know. And for our viewers and listeners that have never heard of this.
Yeah, never heard of it. Yeah.
What is it in a nutshell?
Great question. So I think collaborative divorce can best be understood by comparing it to traditional litigation.
Okay.
Most people understand traditional litigation. We've heard the horror stories with the divorce that went on for years and cost way too much money. So I would say collaborative divorce is a reaction to that system. In a collaborative divorce case, the judge is not the audience. The parties are not tailoring their case and gathering their evidence to try to persuade a third party that they are right. And instead, the audience is the other party, is the children in the case, because what we're trying to achieve is a mutually agreeable, sustainable situation where both parties have bought in to the new status quo that they're going to create. In a collaborative divorce case, we acknowledge that this is a legal process, an emotional process, and a financial process all at once.
Yeah.
So the people who are helping the family through the process are of that profession, of those professions.
Okay.
So in a collaborative divorce case, each spouse would have their own collaboratively trained divorce attorney. And this person is giving independent advice to each of the parties, very similar to litigation, in the sense that each has their own attorney.
Yeah.
Collaborative divorce differs insofar that we assemble a professional team based on the needs of the family. So those people are usually co-parenting coaches, if they have young children or children, communication coaches if there are no children, but the husband and wife have room to improve their communication. Accountants and financial professionals, CDFAs, CPAs, appraisers, loan officers. These are the common other types of financial professionals that you need in a divorce case. You need their opinion, you need their expertise to help the family make an informed decision. So in a collaborative divorce case, the professionals, the attorney specifically, sign a very comprehensive stipulation at the beginning of the case. That is the hallmark of a collaborative divorce case, is a collaborative stipulation being signed at the beginning. And one of the most important aspects of the stipulation is the disqualification clause. In the disqualification clause, the attorneys are making a promise to the parties and to each other that if the collaborative process is not working and the case needs to transition to litigation, that attorney is promising that they will back out of the case. They will not continue in the case as a litigation attorney.
Why is that a good thing?
It's unique because most attorneys in another type of case, they would just stay in the case. They would just switch hats and say, okay, now I was being a mediator for the last year, trying to work amicably to keep the family out of court. But now I'm just going to shift gears and transition the case and serve discovery and start gathering my evidence, my trial binders and my exhibit binders. It's a very different mindset. And so I think, is the professional really committed to an out-of-court settlement if in the back of their mind they're really positioning or strategizing about going to court? So in a collaborative case, the professionals from the beginning were not thinking about the most legally strategic, aggressive, or we're not trying to pursue everything we can. We're pursuing what the client tells us are their goals. Yeah. The client's needs and the goals are what is driving the professional's motivation.
So is it just the attorney that would be stepping away if it was disqualified, or is it that whole team? I know you mentioned a number of different professionals there. Would it be that whole team that would have to step away?
I think it includes the work product from those professionals as well.
And would you say
so? Yes.
In your experience, does that perhaps that potential negative reinforcement help the parties really try to work together to get it concluded amicably instead of the idea of having to start over again if they keep squabbling?
I think it's a huge incentive. It's a huge monetary incentive, time incentive to stick with the process that you agreed to at the outset. People agree to collaborative because they believe it's the healthiest, most holistic approach to support their family during its most dire time of crisis. So I think that, I'm sorry, I lost the rest of your question there.
What did I say? I don't remember what I said. What did I say?
Oh, geez.
See, if we were in court, I could get a read back, a court reporter read back.
I know. I said, I guess, how does that encourage
people to stay through the process?
Thank you.
Does the I guess the potential negative reinforcement of having to dissolve everything and start over, does that kind of encourage both parties to play nice and try to get through this process instead of continuing to fight?
I think it absolutely does. It absolutely does. Go ahead. Jim.
Yeah. I hadn't heard of the term collaborative divorce until probably last year. So is it kind of more of a newer approach that has just come up in the last 10 years or so? Or has this kind of always been there, but, people started to talk about it more then?
Collaborative divorce has been around for a few decades.
Wow.
Okay. I think part of the reason why it hasn't caught on, very few family law attorneys are trained in collaborative divorce.
So what training is involved? How is it different from going to law school or whatever other training divorce attorneys go through?
Yes. So I think every attorney kind of has their own path as to how they get to a collaborative divorce training, because law school teaches us to litigate. Law school teaches us the rules of evidence, the code of civil procedure. It's teaching us how to go to court. So when attorneys make a conscientious decision to step away and say, there are flaws with this litigation approach, there's collateral damage to the system that we have in California. And once you see a new system that works, that supports the family, I couldn't unsee it. I couldn't not pursue it.
Yeah, it almost seems there needs to be a bit of a rewriting on of how that education could even start off from the beginning there.
Yeah.
There could be this different track, like doctors have different ways of going down, becoming a doctor there.
I agree. The training to become a collaboratively trained attorney, it's only offered once a year. It's 3 days of training, consecutive days. That's hard for a working attorney to have, half a week that they have to be in class. It requires essentially what we call a paradigm shift, where you imagine that the courts don't exist. You imagine that, the witnesses that you would need to prove up a certain claim, you almost, I don't want to say pretend they don't exist, but it's not so much about being factually right. It's about convincing the other side that, this is a reasonable claim, and that together with the holistic global settlement on all of the issues, on custody, on support, on the house, on the mortgage, on the refinance, that there's goodies for everybody. And no trial judge would come up with such a perfectly curated or crafted, tailored ruling for that family. So it's the family coming up with the perfect arrangement, the optimal, situation out of a bad situation.
Yeah.
Versus in court, the courts tend to impose kind of rubrics or formulaic orders on families. They're not really tailored to the nuances or of the family. So I think a lot of people, after a trial, they walk away and they feel dissatisfied.
Yeah.
They feel that the judge didn't really hear them. The judge didn't really understand what was happening in their family. And I don't really have clients after a trial say, wow, that was a really rewarding experience. That was a great use of my time and resources.
Whereas in collaborative, you do have clients that say that?
Yeah.
I do. And one other thing I want to mention about why collaborative is not more, popular. Litigation attorneys make more money litigating the same issues in a collaborative divorce case.
Yeah, I was wondering, you were talking about all these members who could be part of the team though. So is that one of the roadblocks that stops people maybe going down that collaborative approach of maybe thinking that it could be or will be more costly?
Yes, I think that's one of the bigger barriers to people signing the collaborative stipulation, to people signing on to make this a truly collaborative case.
I imagine though, if you go to litigation, it could actually end up costing.
Spiral.
Yeah,
it can absolutely cost you more. And you'll end up seeing these professionals again through the litigation process, but in a different capacity. They're court-appointed experts under Evidence Code 730. They're now in a formal process where they can't just kind of pick up the phone and send an email. They have to write formal reports to the court, subject to cross-examination. The family's paying through the nose to have the same expert apply their skill set and ultimately make a recommendation to the court. And the expert is trying to convince the court that they're correct.
Much more adversarial.
Much more adversarial.
So I have a couple questions. I hope I remember both, but
do you want to whisper one to me quickly so I won't forget and we won't tell them what it is?
In my mind, I see both teams, so both both spouses' teams in a room, and you guys hash it out together. Is that literally how it is? Do you all sit in a room together and talk, or?
That's great question. Great question.
Is everyone
Are we in a boardroom?
And you're always paying for everyone's time?
I would say there are certain types of meetings where they're full team meetings. Okay. Full team meetings are important, but because of the intense costs that the family's paying for that 1 to 2 hour meeting, it should be something where everybody is in agreement that a full team meeting is appropriate. We have an agenda about what's going to be discussed. Everybody is prepared. Everybody has the relevant information they need walking into that meeting. And I want to come back to the professional team.
Yeah.
I think the heart of a collaborative case is really having a mental health professional in the case. That is really what I would say transforms it to feel like a collaborative divorce case.
So it could almost just be that, collaborative attorney plus maybe even just maybe a couple, like it doesn't have to be that big extensive team now, does it?
No.
Yeah.
Having one mental health professional who is serving as a communication coach or co-parenting coach.
Okay, so they're not actually providing therapy to anybody.
No. And that's an important nuance.
Yeah.
Everything I've been referring to these mental health professionals is coaching.
Coaching.
When you're under therapy laws, you have privacy, you have HIPAA. There's no way the attorney could hop on the phone and hey, how did that session go? What issues came up during that? But when the family makes an informed decision that the family can retain a mental health professional, not to do therapy, but to do coaching as part of the collaborative team, that authorizes the attorneys to talk with the mental health professional if something urgent comes up right before Christmas break, winter holidays, which inevitably comes up in every law firm. There's some kind of crisis.
Yeah.
Instead of only having two attorneys on a busy, Friday afternoon to hope that they have time to get on board, the family has now this third option. They can call up their co-parenting coach and saying, hey, we're having a dispute on the custody schedule. And instead of the family now paying two attorneys those hourly fees, to then talk to their clients, the family can go just directly to the most appropriate expert in that situation, which is a custody dispute. Go talk to your co-parenting coach. So in a collaborative case, the family can kind of pick and choose which expert they want to rely on depending on what issue comes up.
What kind of needs they have.
When a legal issue comes up, you call your attorney. When a financial issue comes up,
and that person's got a clear idea of all this other stuff that's going on there too in the background.
Yeah. So if they feel like they know they're probably going to have a financial disagreement, they can have a CDFA ready.
Yes.
If they know that they have disagreements about parenting or custody, then they know they can have this coach.
Yes.
But going back to the mental health professional, any of the professionals, do they also need special collaborative training?
In California, our protocol is that you have to attend a 3-day collaborative training.
Okay.
We have one in Southern California. I believe there's one in Northern California. So the therapists who are hired as co-parenting coaches, they have attended the same collaborative training that the lawyers take, that the CDFAs and accountants take, and that the therapists take, because we're creating this professional team. It's not an attorney-led process in a collaborative case. In litigation, it's entirely attorney-led.
Interesting. So it's client-led.
It's client-led. Clients making informed decision-making throughout the process as to what kind of professional do I need. Usually one parent thinks we need a lot of co-parenting coaching. One parent says, everything's fine. You're just being dramatic. I think if the family can agree to 2 hours of co-parenting coaching, those 2 hours can pay dividends for them for years to come. And it's a skill set that attorneys just frankly, we don't have. We don't have it. We're not trained in that. And so kind of putting your ego aside and delegating a piece of the case to the appropriate expert, that's an example of how attorneys make less money on a collaborative case, because we're sharing the work with the most appropriate expert that the family has voluntarily selected.
Now, going back to just the beginning, so let's say one spouse has heard of collaborative divorce. It's like the perfect option for us. I know this is going to work. And the other spouse is like, what the hell's that? Like, how does a spouse educate and convince their spouse, like, hey, maybe we should do this? Like, do you have any recommendations?
Yes. There are a tremendous amount of resources online. aBetterDivorce.com is the South Bay's local collaborative divorce group. We also have Collaborative Divorce California, which is a statewide collaborative divorce website with a tremendous amount of resources. But practically speaking, what happens is usually the spouse who wants the divorce, they're usually the petitioner in the case proceeding, but not always. They're the person driving it. They're the engine. So oftentimes the engine is dragging the other spouse along.
Yeah.
Not always. Sometimes they're mutual in agreement. They're in lockstep. The pacing from the professional team is quite easy if they're both in agreement. But a lot of times one spouse wants a divorce and the other spouse thinks, hey, we can go to therapy. Let's try to work this out. So that is why having a mental health professional in the case, as they're trying to start to make legal decisions and accept the reality that they don't want to accept.
But what if the other spouse is like, well, I've heard of mediation. I heard, for amicable, why aren't we just going that way? I don't know what this collaborative thing is.
Yeah. And I think that there's a lot of conceptual decision making that goes into having a collaborative stipulation signed by both parties at the beginning, in part because of that pacing.
Yeah.
If they're both in agreement that the divorce is the right thing for us, we don't want to waste all of our money in an expensive adversarial hearing. We want this to be private. We don't want this to be in the local courthouse where all of our neighbors can hear all of our business. Those are the people who are usually more inclined to a collaborative divorce case. But what typically happens is when one spouse, the engine comes in and says, I want to get a divorce, my spouse is not on board yet. What I typically do is I will write a letter to the other spouse and introduce myself, educate them about collaborative divorce as an alternative to litigation, and you really empower them to make one of the first of hopefully many decisions about, are you willing to retain a collaboratively trained attorney to keep this case out of court amicably? If so, you have 2 weeks, 3 weeks, give some kind of reasonable time frame so you can measure whether or not they're responding.
Yeah.
And you sit back and you wait, and oftentimes the spouse is peppering them with email links and information and
trying to drag them along.
Trying to drag them along.
Just educate.
But it really requires someone to pull their head out of the sand and accept what's really happening, and to start trying to make self-interested decisions, not at the expense of the other members of your family, but to start accepting that I need to start standing on my own 2 feet.
So I feel like we've talked a lot about why collaborative is, I think, a more amicable, mentally healthy alternative to litigation. But let's talk about mediation versus collaborative. What's the difference? Why would one choose one versus the other?
What aren't you getting?
Because I feel like both are friendly. So
it's a great question. So in a mediation case, it's way more amorphous. There's no collaborative stipulation signed. Mediation often means the family hires one joint mediator. And that is very different from each spouse having their own attorney to speak with and to
represent their interests.
Independent legal advice. So in a joint mediation case, the family is usually wanting to spend the least amount of money, which is understandable because these professionals are not inexpensive. At the same time, the family is looking at splitting into two households on the same income. So it's a tremendously financially scary and tight time for most families. So in joint mediation, that joint mediator is not providing independent advice to either party.
Yeah.
And we noticed that during our respective divorces. It's like, I thought they were going to advise us in some way, and nothing.
And mediation, I do have many mediation cases where there are two attorney mediation cases. I call these consulting mediation attorney cases, where the parties each have their own attorney. That attorney is advising them from their perspective and representing them in negotiations with the other attorney. And those two attorneys have kind of a gentleman's handshake that says, we're not going to go to court. I'm not going to serve you with discovery. We're not going to file any motions. But that's very different than a collaborative stipulation where the attorneys have signed on the dotted line that they will get out of the case.
Yeah.
They will walk away from those attorneys' fees if the client decides to litigate.
Yeah.
So
sounds like an attorney's found a little bit of gray area there.
So it's very common cases start out as mediation cases and then they fizzle out and they transition to litigation. Nothing stops the process from having that same attorney continue in that same capacity. And a lot of attorneys do continue in that same capacity.
Yeah.
And so, but it's just a different model. Your attorney is having to switch gears midway and, but it happens.
And I guess there's not that potential negative reinforcement that, we're going to have to start over if we don't cooperate with each other.
And mediation is very popular because you can still utilize those same professionals that we discussed in the collaborative case. You can bring them into a mediation case if the family agrees and says, we want a co-parenting coach, we want a CDFA, we want a CPA to value this business. That's really common. So mediation cases can kind of look and feel very collaborative, but the real measure as to whether or not you have a collaborative stipulation is, have you signed a collaborative stipulation? Has that been filed with the court? If so, the court literally pulls your file out of the general circulation so that you don't get roped into the status conferences that people get roped into in litigation cases. So it's telling the world externally that this is a collaborative case and there are real enforceable consequences that attorneys have to walk away from the case if the family decides they want to litigate.
Yeah, I like that. Sometimes people need the formal agreement to play nice, so.
That's very true.
Yeah. Well, Nicole, thank you for introducing us to the world of collaborative divorce. And I feel like our viewers have learned a little bit. Yes. I think I've learned stuff.
Yeah, for sure.
So
it was great to be here. I'm so passionate about collaborative divorce and helping families stay out of court, helping them heal and learn to communicate better. They're still communicating. Even if they don't have minor children together, a lot of adult children, family vacations, family holidays, all of those traditions continue. So it's really important to help families learn to be civil, to be in the same room together so that their kids, even adult kids, still have their mom and dad around together.
It's never too late. Never too late to learn something new and communicate better.
Yeah. Before we let you go, we're going to have you participate.
We're going to put you in a hot seat for a second. Yeah.
And you're going to play the game Divorce This or That with.
You're getting divorced. Choice 1. It's a super adversarial divorce, litigious, just terrible. All sorts of stuff going to court, accusing each other of things. But oddly, the person that you're divorcing is the nicest human on earth, which I don't really understand. So perhaps if you get through this litigious phase at the end, maybe you two can still have some kind of civil relationship. Option 2 is you're going through a collaborative process, but your spouse is actually kind of insane and irrational and nutty and may or may not collaborate even though everyone signed the agreement. Which one and why?
I would choose option 2.
Okay.
I would put faith in the collaborative process that the collaborative attorneys, the co-parenting coach could shift the mindset, shift the dynamic that you're describing with that really insane spouse, that insane person.
Mentally challenged.
Who's still up for going through the collaborative divorce process.
And to me, that person, they're crying out for something. They have some really big need that they don't feel is being met. So I'd really want to uncover what is really going on underneath that behavior to get to really understand that. Otherwise, adversarial court hearing case.
Yeah.
No, the process is just not worth it.
Yeah, your face tells us all of it.
Yeah.
All right, Jay, go ahead.
No,
Tell us your option. Tell us your choice.
Yeah, I would go with the. Well, actually, I would go with the first choice.
Why? Why?
Because I'm gonna fire my. I think because I'm a nice person, and the other person, like Mr. Rogers, is also really nice.
You're gonna fire your San Diego team?
I think it's the San Diego lawyer team, and we're just gonna fire them and find some better attorneys quickly before we've racked up too much of a bill. We'll kind of get it done there.
Don't hire from a billboard.
Yeah, because I didn't have kids, and
you've decided that you don't have kids in this situation.
All don't have kids. So.
Yeah, so you're changing the
that
choice
was my angle on
a little
that one,
bit.
Yeah.
Okay.
Yeah.
Well, I'm going to pick option 2, collaborative, because if we have all these different challenges, and maybe my spouse's challenge is some sort of mental health, then we're going to bring in that suite of coaches that have that special training in mental health to address our communication challenges as it relates to whatever's going on there, and hopefully get past it in the collaborative process, since we all signed on the dotted line, and I don't want to start over. So
nice approach.
All right, so Nicole, really quick, you mentioned something in your bio that I can't see through your shoe. There is a Divorce with Respect week in March. Really quick, what is that? Because I thought that was interesting.
Yes. A few years ago, we were able to have a statewide recognition for collaborative and mediation divorce, and we've called it Divorce with Respect Week. Gavin Newsom has endorsed it. Many local cities have endorsement. We've gotten proclamations from many cities in support of our Divorce with Respect Week. But it's really just a PR marketing effort through Collaborative Practice California to raise awareness about collaborative divorce, help families to understand and learn more about collaborative divorce and how it may help their family through a really difficult time.
And look, collaborative divorce as an option, I think, has gained a lot more popularity here in California. It's available in all states. Maybe it might be a little bit more challenging to find that collaborative lawyer in some states versus others, but it does exist as an option.
It does.
If that's something that you're interested in. So,
and some people, on like Instagram and they're looking for a conscious uncoupling. So it's a similar.
I've heard that term. Yeah.
Yes, I think that's more of a California term, celebrity Gwyneth Paltrow term, but it's a similar concept of a holistic approach to supporting the family during a horrible time of crisis, of loss, of grieving, of mourning, of rebuilding.
Yeah. So I think it's a wonderful option, and I'm glad that we talked about it today. So
thank you, Nicole, for joining us. Yeah.
Thank you.
It's a pleasure to be here.
All right, I'm Jo.
And I'm Jade, and this is another episode of Cover Your Assets.